I got to be honest with you. The last few weeks have been among the hardest, the most difficult, and the most discouraging for those of us in the pro-democracy movement. Now, let me take off the table what many people are worried about, what a lot of the questions I get are about. No, I don't think Republicans are going to be able to rig the maps to keep power next November. I think Democrats are still well positioned to retake the House. And in fact, I grow more optimistic every single day that they will retake the Senate as well. No, the concern I have is not about what the partisan breakdown of Congress will be after the 2026 midterm elections. It's not even how we're doing in court. I mean, the fact is, outside of a handful of cases involving redistricting, the pro-democracy team is winning in court. I mean, let's be honest, the Department of Justice tried to get access to the most sensitive voter data that the states have more than 6 months ago. And they are right now still 0 for 6 in cases that have been decided, and in no case have they gained access to that data. So it's not that I'm worried about the outcome of the 2026 elections. It's not even that I am worried that Donald Trump is becoming more of an authoritarian. No, what I am concerned about is that the foundation of democracy is on fire. The Republican Party are a coalition of arsonists. And the courts, in particular the U.S. Supreme Court, is sending cultural cues to the broader public that what the Republicans are up to is the new normal in America moving forward. So there's a lot to unpack here, and I'm going to walk through this. The one thing you can do for me right now at the beginning of this video is really simple. You can subscribe to Democracy Docket. It's the news outlet I founded, and frankly, getting it in the hands of more people is more urgent than ever before. So please do me a favor, click on the link in front of you right now or in the description below. If you want to type in the URL yourself, it's democracydocket.com/YouTube. So here is why I am so worried. Supreme Court decisions decide not just what is lawful and unlawful. The High Court doesn't only decide what is constitutional and not constitutional. It also sends cues as to what is right and what is wrong, what is moral and what is immoral, what the shape of the field of debate is, what the Overton window of acceptable and unacceptable are. And it's able to do that because the United States is a nation of laws. We are a people that take great pride in the fact that we have the oldest constitution in a functioning democracy today, that we are governed by rules and a constitution that supposedly at least treat all people equal under law. Now that is fraying, and it's getting worse, and you know that, and I know that, and Donald Trump is to blame for a lot of that. But like I said, he's not doing it alone. He's doing it because he's got a Republican Party that at every step of the way is cheering him on, both because they are his sycophants, but also because it is the only way in the face of his rising unpopularity that they think they can hold power. So why do I bring this to the Supreme Court? Well, because in a country that prides itself on the rule of law, in a country that takes its cues from the legal decisions that come out of the Supreme Court as to what is acceptable and unacceptable, those opinions can take on lives of their own. So I would argue, for example, that without Plessy versus Ferguson, separate but equal, you never have the cultural acceptance of the Jim Crow South. Sure, Plessy versus Ferguson was a terrible decision. It was one of the most abominable decisions in our nation history. It is a stain and a black mark that will never be erased. But if it had just been a court case, there could still have been social disapproval of what became Jim Crow. But instead, because the Supreme Court had ruled the way they did in Plessy versus Ferguson, it gave a permission structure to the adherents of the lost cause, the former defeated armies of the Confederacy, to act as if they were the moral ones. They were the righteous ones. That what they were advocating, what they were implementing in the horrors of Jim Crow was consistent with the rule of law. I'll give you another example. Donald Trump instigated a violent insurrection on January 6th, 2021. And in the days after that, he was held in pretty low esteem. He was actually persona non grata, even within the Republican Party. You've all seen those videos at the time of prominent Republicans denouncing Donald Trump, and now they act like they never did it or they don't remember it. But that's because at that time, what Donald Trump had done was viewed outside of the bounds of acceptable behavior because he had instigated this violent insurrection. He had probably broken the law, the thought was, and he would pay the penalty for it. When the Supreme Court granted him immunity, it didn't just shut down Jack Smith's criminal investigation. It didn't just mean that he could escape without any legal consequences. No, what it did is it built a permission structure for his supporters, for others in the Republican Party who are not sure they were his supporters, and for mainstream organizations, corporate America, legacy media, you know who I'm talking about, to treat Donald Trump as if his role in that January 6th insurrection was acceptable. It was normal. It was not out of the bounds of what we expect from our elected leaders. Now, obviously, you don't agree with that, and I don't agree with that, and I think that Supreme Court decision was wrong. And even if that Supreme Court decision was right, it still doesn't justify what he did. But we have to be honest. When the Supreme Court says that something is okay and constitutional and legal, or illegal and unconstitutional, it carries with it that cultural baggage. I'll give you one more example. The Supreme Court decision in Citizens United. Technically, all the Supreme Court said was that corporations can make independent expenditures. Individuals had had the constitutional right to make those same expenditures all the way back from 1976, but they weren't making them, or at least they weren't making them in large sums, and not many individuals were doing it. What Citizens United did was not just decide a legal principle. It set a cultural norm. It created, again, a permission structure for wealthy people to put endless amounts of money into the political system. And that had itself a catapulting effect forward in loosening up and ultimately leading to the campaign finance system that we have today, which is frankly barely a system at all. Now, the defenders of Citizens United would say, the opinion didn't do any of that, but I'm here to tell you that the opinion did all of that, not as a legal matter, but as a cultural matter, in the same way that Plessy versus Ferguson decided a legal case, but it also set in motion decades of horrific discrimination and death in the Jim Crow South. And so part of why the last few days and weeks have been so hard, and I think this is probably what many of you are feeling as well, but you may not have been able to articulate, is not that the Callais decision, the Supreme Court case involving the Louisiana redistricting map, it is not that that decision in and of itself is the only problem. Yeah, it's a terrible decision. I've already said that it and the procedural case that followed it immediately after are probably the worst Supreme Court cases of my lifetime. But the problem with them is compounded much further by the cultural effects that those decisions are already having. So what do I mean by that? Well, let's start with the day after the opinion comes out, right? The narrow holding of the opinion was that the Voting Rights Act is constitutional, that race can be used to draw districts under certain circumstances. That's what Sam Alito wrote in his opinion. Now, I thought it was disingenuous. I said that. I thought it was cynical. I said that. I thought it was an effort to mislead and to obfuscate what they were really doing, which was gutting the Voting Rights Act, and I stand by that today. The Supreme Court decision did not say that every district in the country in which Black voters or minority voters express power to elect their candidates of choice, that they are constitutionally suspect. It did not say that every Black elected member of Congress should now be viewed askance, that the Department of Justice, that Republican Party operatives should be targeting them as if somehow they were illegitimately elected. The Supreme Court didn't say that. Just as the Supreme Court in Plessy versus Ferguson didn't construct the Jim Crow South that came after it for 6 decades. Just like the Supreme Court in Citizens United didn't start super PACs by name and didn't say that wealthy individuals should give money. No, what the Supreme Court did in Callais is the same thing it did in those other cases. It gave a permission structure to those people who want to destroy democratic norms, democratic institutions, and take a sledgehammer to free and fair elections. So let me give you a real concrete example of what I'm talking about. The day after the Supreme Court issued its decision, Eric Schmitt, a Republican senator from Missouri, a former state attorney general, this is a lawyer, this is a guy who knows better, sent a letter to the Department of Justice telling them to essentially investigate all so-called Section 2 districts in the country. Now, the fact is, as Senator Schmitt knows, there is no master list or directory of Section 2 districts. And as he also knows, there are far fewer of them than most people think. But what he next said was even more telling. He suggested that the Department of Justice not just investigate these nationwide, but in fact, they should start in California. Now, why do I think that's so significant? Because, you could imagine a Republican senator, a conservative, someone who I don't agree with on anything, saying we should start in Alabama, Louisiana, Mississippi, like Tennessee, right? You could imagine that. I still am critical of that, but you could imagine him doing that. But why did he start in California? And it's highly curious because we know that the California map doesn't have any Section 2 districts because it was drawn avowedly based on party. It is what we colloquially refer to as a partisan gerrymander. Gavin Newsom, the governor of California, when he was arguing that the voters of California adopt this, said it was a partisan gerrymander to offset Texas's map. The proponents who spent tens of millions of dollars telling Californians to adopt this map made clear this was a partisan gerrymander. When Republicans sued and argued it was drawn based on race, they lost in federal court. The federal court said it was a partisan gerrymander. And in fact, the U.S. Supreme Court said it was a partisan gerrymander. So there is no Section 2 district to be found in California because the motivation of this map was partisan. Now, that isn't the only reason why there are no Section 2 districts in California. I could go into the law of Section 2 before the Callais decision, after the Callais decision. However you slice it, California does not have Section 2 districts. What California does have are minority communities that are able to elect their candidates of choice. And in some of those instances, they have elected Black and Latino members of Congress. You see, what's happening here, everyone, is that the Republican Party is not going after illegal Section 2 districts. It's not trying to ferret out the unlawful use of race to move voters inside and outside of lines and create congressional districts. No. What they are targeting are Black members of Congress. What they are targeting are communities comprised of minority voters who are able to elect their candidates of choice. Going after Black elected officials and going after minority voters is not going after Section 2 districts. It is going back to a time when Plessy versus Ferguson was the law, when Jim Crow was ruling the South. It is a mindset based on not advancing a race-neutral theory of democracy. It is based on a racist theory of democracy. That it is not possible in their telling of the story that absent some tinkering, absent some preference, absent some intentional line drawing to the benefit of minorities, it is not possible in their view that a Black member of Congress would be elected, that Black and Latino members of a community would band together and elect their candidates of choice, that white voters would vote in concert with, in supporting the Black candidate of choice or the Latino candidate of choice. They cannot actually imagine that that would be true. So for them, starting with California makes all the sense in the world. But you know and I know it's not really about California. It's not really even just about Louisiana or Alabama or Mississippi. It is about taking a sledgehammer to American democracy, taking a sledgehammer to a multiracial American democracy. And the vehicle through which they want to do that is this Callais decision. Democracy Docket has covered this from start to finish. I've written about it. The reporters have written about it. We have had guest authors write about it. Please do me a favor and support that hard work by becoming a Democracy Docket subscriber right now by clicking on the link in front of you or in the description below, or by typing in democracydocket.com/YouTube. So here is what the Republicans want this all to look like. They want to discredit the idea of minority representation. Because if they can discredit the idea of minority representation, number one, they are able to turn every seat in the South into a Republican seat. They can, in fact, racially gerrymander while saying that they are doing it to not allow for the use of race. I mean, it's the classic thing we deal with these days with Donald Trump and the Republicans. It's like their accusation is the admission, right? So they are claiming that they need to go after these race-drawn Section 2 districts that are illegal. And so to do so, they are gleefully, they are joyfully, they are celebrating the dismantling of Black communities, Black voting communities, cities like Memphis. They are carving up, not because keeping Memphis together is unconstitutional, but because keeping Memphis together gives Black voters a voice in American democracy. I mean, look, you can look throughout these districts in the South and you will be surprised how many of those districts you have white voters in cities voting for the same candidates as the Black voters in those cities. And sometimes they're electing white candidates, sometimes they're electing Black candidates, but they are working in concert to try to advance a multiracial democratic future. And that is just something that the Republican Party can't tolerate. It is something that, frankly, is so deeply threatening to them, is so deeply inconsistent with their worldview and their lies that they tell their supporters. They cannot tolerate those districts existing. So instead, they caricature them as if they are some creation, some race-driven creation manifesting some illegal activity. I think the Supreme Court got this case entirely wrong. I think the test that was being used before Callais to determine what was and was not a Section 2 district was the right test. I'm not the only one who thought that. I mean, I won cases in the Supreme Court on it where conservative justices agreed. I've watched as Republicans in the past have agreed. We all watched as Congress voted to reauthorize the Voting Rights Act with that test, 98-0 under George Bush. Those of us who are old enough to remember Ronald Reagan calling the Voting Rights Act the crown jewel of American liberty. Now, I sometimes misquote him, and others do as well, and we say he called it the crown jewel of American democracy. But, you know, I went back and I reread it, and what he said was the crown jewel of American liberty. I think that's really important to take a second to focus on. He wasn't so much saying that the Voting Rights Act was essential to the democratic process in the sense of, you know, free and fair elections. That's how I think about it. You know, I think it's the crown jewel of American democracy, or was. No, Ronald Reagan was saying something uniquely Republican, uniquely resonant with his building of the Republican Party at the time, which was a party, in his view, not mine, based on liberty. Right? He saw the importance of equal voting rights for minorities as essential to the liberty of all Americans. We would not be free, none of us, if you did not have the Voting Rights Act in force protecting minority voting. That is gone from the Republican Party. Donald Trump wants authoritarianism. He doesn't want liberty. The Republican Party in the House and the Senate, they want rigged elections because they know they'll lose if there's democracy. So the days of there being a coalition in the Republican Party for democracy or liberty, I mean, those are long gone. But the Supreme Court, it should have known better. In fact, I'll go one step further. I suspect the Supreme Court did know better. I think that the Supreme Court conservatives knew damn well what they were doing. At the same time, they were saying words written on pages that will go in books that will sit on musty shelves in lawyers' offices. At the same time they were doing that, they had a whistle, a dog whistle, blaring loud and clear to Republicans as to what they should say this opinion is about. Because like I said, Sam Alito says use of race constitutional, check. Voting Rights Act constitutional, check, check. Now again, I called it out for being disingenuous and cynical for precisely this reason, among others. Because that may be what's written on the page, but it's not that whistle. It's not that dog whistle that everybody is hearing out there. And I wish I could tell you that the only people hearing it were Republicans. I mean, I just read in one of the large legacy news outlets that, New York State is full of Section 2 districts. I'm sorry, what? No, it's not. I don't like that's nutty. That's like whoever said that either really doesn't understand what Section 2 of the Voting Rights Act or was told by the Republicans a bunch of talking points that without double checking they put down in print. But it's not just New York. It's not just California. It's not just South Carolina. It's not just Tennessee and Michigan. I mean, I could go on and on. The Republican Party wants you to believe that these districts are out there and they are all need to be reviewed and struck down, when in fact, that is not what the printed pages say. But I understand why they are saying it. It is efficacious to their cause of burning democracy to the ground. And yes, I believe that the Supreme Court understood that by doing what it did, when it did it, right? It didn't wait till June when it'd be too late and there'd be time to digest this all anew into 2027. No, they did it at a time when they knew there would be a frenzy. And in that frenzy, in that zeal, in that mob mentality, just like Donald Trump could say, I told them to be peaceful, and we know that was bullshit. The Supreme Court can say, we never said that Section 2 of the Voting Rights Act is unconstitutional. We said the opposite. Once the mob gets going, once you've ginned them up, once they've heard those dog whistles, spare me that the actual words, that the precise language that you used was more measured. Donald Trump was too smart and too savvy to sell that to the American people. The Supreme Court is full of people who are a lot smarter and a lot savvier. And we shouldn't buy it from them either. Look, I'm telling you all of this, not because I think we need to give up on the courts, but quite the opposite. We need to call them out and we need to hold them accountable. And part of holding them accountable is not giving into the narrative, the lies that Donald Trump and Republicans are telling right now about the congressional maps of this country. I have lots of faults about these maps. I have lots of complaints. But any Republican who tells you that they are redistricting because they have to, because it is their constitutional obligation, that is a load of bullshit. Any reporter who takes that and prints it, they are doing the work of Donald Trump and the authoritarians and the Republican Party. Either they're doing it on purpose because they're trying to suck up to him, or they're doing it because they don't know better, or they're doing it because they don't understand the cultural impact that this case is having and how it is clouding the legal analysis. If Republicans are going to target Black members of Congress and disenfranchise Black voters at scale, they should own that. Not hide behind some Supreme Court case. Not hide behind some theory or legal argument or whatever. They should own it, and we should insist that they own it. I've said this over the last few days. I said this to Nicole Wallace. Yeah, the civil rights groups are speaking out. Of course they are. They're the ones being targeted. But where are you? Where am I? Where are we? Where are the rest of us? Are we speaking out as loudly as they are? Are we as offended as they are? Because we damn well need to be. We damn well should be. Because what is happening right now is wrong. This cultural moment in which a Supreme Court case is being used to gut voting rights and set the clock back, it is immoral. It is anti-democratic. It is outright wrong. And that is the culture that we need to assign to this case and its progeny, and to the consequences, and to the letters that come from senators from Missouri, that what they are doing is immoral and it is wrong. Do not give them the courtesy of clouding it and complicating it. Do not give them the room to claim falsely that they are required to do this or do that because of this court decision. These are choices they have made. These are choices they have made because they are following Donald Trump, and Donald Trump is unpopular. These are choices they have made because they are so morally bankrupt and so committed to this authoritarian in the White House that they will do or say anything to keep him in power and keep themselves in the majority in the House. But it's not going to work. And it's not going to work because you and we're not going to let it work. We are going to stand up in solidarity with the minority communities being targeted. We are going to stand up and call out every miscitation, every abuse of this case for other purposes. And we are not going to allow it to transform itself into a cultural moment in which it stands for a broader proposition that there is somehow an illegitimacy to minority voters expressing their political power, that somehow elected representatives, people who have won elections and had those certified and have gone and taken the oath of office and served in Congress, we are not going to stand by and allow them to be maligned and somehow treated as if what they have done is any lesser than what any other member of Congress has done, that somehow their presence in the body is somehow less legitimate. So we need to do that. And look, I do these videos because I am trying to help keep you informed and armed with the information you need to be part of this movement and to share this good information. So you can start by subscribing to this channel, by sharing this video, by leaving a comment. I love reading your comments. But ultimately, if there's only one favor you're willing to give me, it's to subscribe to Democracy Docket and then share that content, because the written content you will get from Democracy Docket is going to give you the tools you need. And you're going to help it do its work to tell the truth without fear or favor. There are no corporate overlords. There's no private equity investors. We rely on you. So please join us. Thanks. I'll see you next time.